name is Sandy Weidner. This is 2022. In the year 2000 was the year I was first elected to City Council, and I served on the City Council for 20 years. In 2017, 17 years into my run as alderman, I decided to run for mayor. That was in July of 2017. By August, 4 weeks into my campaign, the city attorney had decided he did not like the tone and tenure of my campaign because I was calling out the city on a lot of the issues that were in part created by the administration there. So he called this executive committee meeting and asked the council to approve sending the majority of what were my emails to the ethics board. I never had a problem with those emails going to the ethics board. I had served on council with 2 previous city attorneys. I knew as well as the back of my hand exactly what attorney-client privilege and confidential was. None of the emails that were presented in the executive committee were, in my view, attorney-client privilege or confidential. With the new city attorney, now keep in mind I'd worked with Scott Letney for 7 years prior to him becoming city attorney, and I'm a pretty good judge of character. And when he asked the council to send those emails to the ethics board for review and advisory opinion on if he was the one that was correct and that anything that came into or out of the attorney's office was attorney-client privilege and confidential, I was perfectly fine with the ethics board making an advisory opinion on that. The issue that I had is that I wanted to be sure that the same emails that were presented in the executive committee were the same emails that were presented to the ethics board. So I decided that now is the time to talk about my court case. Ironically, it's because on Wednesday, August 17th, will mark 5 years since the date of the executive committee meeting in which City Attorney Scott Letney had presented to the council a PowerPoint presentation consisting mainly of my emails. So the city attorney's attorney has made an offer, and mind you, when the defendant makes an offer, they get to tell the court that they made an offer. They don't have to tell what the details of that offer is. So it's very easy they could make an offer such as they made to me, and I decline it, and the judge would never know how paltry this offer is. So what has been proposed to me is that the city would not file a petition for a review of the 2nd District Court of Appeals remand to the Wisconsin Supreme Court. I would welcome that. I would love for the city attorney's attorney to file an appeal to the Wisconsin Supreme Court, because I believe that the ruling would come down much the same as the appeals court. The next thing is the city would stipulate that I could see the PowerPoint, both versions. Now, I don't think I mentioned previously that part of the problem is there was more than one PowerPoint that my attorney had found that the city attorney had created. He'd only submit one to the court, but it didn't match anything like the emails that were sent to the ethics board. So when he questioned it, then the city attorney remembered that actually there were 2 PowerPoints, so he submitted another to the court. And Judge Kirkman thought, oh, it's no big deal, they're basically the same. So he just let that go. So in this offer to me, the city would let me see, just me, see both of the PowerPoints consistent with the Court of Appeals decision. The city would agree to stipulate to the vacation of the contempt order. So I think I mentioned earlier that I was found in contempt. I'm facing an $18,000 contempt fine from Judge Kaskakevich's court. And the city evidently has the ability to have that contempt order rescinded, although the judge also has the ability to dismiss the whole contempt charge, something that I'm hoping that he will do. So the city would stipulate, and they would waive any claim to fees and costs associated with the sanction order. So the sanction fine from the contempt order is what the city claims it cost them to file a motion to the court regarding my contempt. Ms. Weidner would waive her claim to fees and costs of the city. I have financed myself the entire attorney fees for my case these past 5 years. And state statute is the prevailing appellant, which was me, would be reimbursed their legal fees. So the city is proposing that I waive those. So very generous of them. The parties would mutually release each other for all claims relating to arising out of Ms. Weidner's public records request. That will never happen because I fully intend to pursue filing charges in federal court because my civil rights were violated. This whole thing was conducted by the city attorney and I believe then candidate, now Mayor Corey Mason, to keep me from having a successful bid for mayor back in 2017. And then the final portion of the agreement was that the parties would file a stipulation for dismissal and proposed order dismissing all claims with prejudice and without cost to any party. I don't know why he even threw that in because none of that makes any sense. So there were 2 words that I used in my response to this request. One word starts with an F, the other one starts with a Y. The city attorney, from the beginning, had misconstrued deliberately what attorney-client privilege and confidential is.